Happy Summary Judgment Day, everybody. We've already got one. Let's see if we get more. I think we should get at least one more, probably two. In honor of it being Summary Judgment Day, I am going to post this video on YouTube because I'm going to talk about some substance. So if you are a YouTube person, I usually do videos in the morning in my closet, at least a couple times a week. At the end, I'm going to show you what I'm wearing. If you don't give a shit about that, you can just stop watching. I really appreciate those of you who commented last night that you could tell I was excited. And I geek out over like cool strategy. I love strategy. It's my favorite thing to do in my job. Some people get a real big kick out of, going up there and giving closing arguments and examining witnesses. I'm like, yeah, that's a rush, but I love strategy more. I think figuring out what to do and how to do it is the most exhilarating part of practicing law. And so when somebody does something unexpected, I'm like genuinely geeked out for thanks for recognizing that. We're going to see opinions on all sides of this thing. And I have never claimed to be in the prediction business here. I'm not going to come on here and say this is absolutely going to happen or this is not what's going to happen. I can guess based on my experience. Sometimes I'm right and sometimes I'm wrong. But I think you should be wary of any commentary that tells you they know exactly what's going to happen, because nobody does. I don't think I like that. But a bunch of you asked, I was actually going to make a video about this last night before that thing dropped, about these other attachments that we got in response to the Melissa Nathan, this motion for sanctions about Melissa Nathan. We got several attachments, one of which was the back and forth between lawyers about some of these documents. And I got to tell you, when you're writing those things, it's not very fun. When you are reading them, when someone else wrote them and someone else is responsible, it's tons of fun. So I went through and read that last night. One thing that I always do, and I encourage you all to do when you're reading an email chain like that, any kind of evidence, is to start at the bottom and read the whole thing. Because sometimes we get like a clip in the middle, and I just don't feel like you get the full picture that way. So I went down to the bottom and read up. So a lot of it, I don't think that I need to come on here and shake my finger at the Lively people, because they've actually proven my point for me, which is that everybody fucks around with discovery. Everybody sends stuff late. Everybody slow rolls. Everybody holds stuff back. Everybody has problems with versions. Everybody fights over metadata. And this just proves that it's happening on both sides. I don't think either party is good or bad. I think it's just the regular way that litigation goes. What I have been mad at the Lively people about with all their motions and all their letters is they act like the Wayfarer people are the only ones doing it. And they're not. Because that's never the case. So to me, this is less like look at the Lively people as like, yeah, it's equal on both sides. Everybody's playing a game. Everybody's fucking around. And this just proves that they both are playing the game. Now, this thing about the 30-point document is pretty fascinating, that according to the metadata on the document that they have produced, it was written in July of 2025. Now, I would hope that they didn't reproduce it because they can't find the original. I'm going to give them the benefit of the doubt there. And sometimes, things get saved and turned and versions and all that kind of stuff. But, I think that this gives the Wayfarer people the opportunity to be like, okay, so you can't find the metadata on something. You've been screaming from the hills at us and filing 10 sanctions motions about not complying with the orders and the court protocols. How about turnabout's fair play? How about you complying with the court's order and protocols? And then they kind of throw back in her face, you're the one arguing that she, litigation should have been anticipated in May of 2023 for purposes of preserving documents. So you claim we didn't do it. Why didn't you do it either? Which again is fair, because nobody's perfect in these things. No one party is perfect, and everybody's playing the game, and everybody has document issues. I can tell you that As the lawyer, very often your document issues are your client. You're like, hey, I need that. Hey, I need that. Hey, I need that. And they're like, oh, I'll get it to you. I'll get it to you. Sometimes that, the clients really can be the problem here. So I don't know if they're having problems with her, if she changed computers. I don't know. But again, I think it's fair to raise discovery problems the same way that Lively raised discovery problems. This common interest privilege with Colleen Hoover is very strange. I don't know much about Colleen Hoover, like on purpose. I try not to learn too much about Colleen Hoover. But if she really did testify that she wasn't ever going to sue, I'm interested in this. Maybe they shared a lawyer for a moment. I don't know. But, again, just like the Wayfarer parties raised common interest privilege, now Lively is raising it. I would hope that the people who are hardcore Lively would read this and recognize that, this is just how both people play the game. And if you don't like Wayfarer's tactics, that's okay, but know that everybody's doing it. Lively's doing it too. Now, people are particularly interested in the whole 30-point list and what if they can't find the original? Can they keep it out of evidence? Blah, blah, blah. Maybe. I mean, you could certainly object to its admission as evidence because it lacks a foundation. You can't authenticate it. You can't prove when it was created and how it's been maintained and all of that. But I think that's jumping the gun a little bit. It'll be interesting to see if she submits that in support of some summary judgment argument she makes. If Wayfarer comes back and says, Your Honor, you can't rely on that, that won't be admissible because we can't find the original. But, it certainly is a little bit of a red flag that we can't find it. But I think it's too early to make predictions about what that means, for trial, if we get there. This was the most interesting part to me, was the last email where they're going back and forth, and then the Wilkie Farr person basically says, I'm not going to talk about this anymore. I'm not going to answer any of the questions that you've raised. I'm just going to wag my finger at you about how you should have done this earlier, and why are you bringing this stuff up now? And I will not engage further regarding the Wayfarer defendant's belated attempts to bring new issues. Okay? So this is a non-answer answer. I'm not going to get into this. So the strategy here for the lawyers is we don't have great answers to these questions, so let's just tell them to go fuck themselves because they're late and we'll deal with it later, which makes sense to me. What I find so interesting about this is look at the date of this email. Wednesday, October 22nd. That is the exact same day that Lively started filing sanctions motions against Wayfarer for failing to comply with discovery obligations. So on the same day, they went to the court to call out Wayfarer about not complying with discovery obligations. They were sending emails to Wayfarer refusing to have conversations about their discovery obligations. And while, yes, that is part of the game, and I don't think anybody is necessarily doing anything wrong or unethical there, it is pretty telling. There's just no other way to read it. All right, this is the getting dressed part. I have to work this from home, and then I have to run a bunch of errands this afternoon with my kid. We just have a bunch of stuff to do, boring, stupid errands. So I'm just wearing jeans and a shirt and gonna put a blazer on when I go out. Oh, but I want to show you my shoes. Hold on. So this is part of my haul from San Francisco. These are from Vince, and they just look like little sneaks on the front, but they are mules, and I love a sneaker mule because who has time to tie their shoes? So I wore them a little bit yesterday walking the dog, but this is going to be their main test run. All right, and it's just a red bodysuit. I probably should have a belt. I don't know that I feel like it. I might button this. I might do one of these. I don't know, but it's just jeans and a jacket and sneakers, and I feel like it looks a little bit nicer than just, throwing on something casual. So here we go. All right, I will be anxiously awaiting what gets filed. Oh, that was the other thing. They're probably going to file them at the last minute, and people keep asking why. You guys, these things take hundreds of hours to put together. It's literally just timing, and they have other cases. So I wouldn't read too much into the timing. I wouldn't be surprised if we get everything at 11 p.m. Have a good day.